Say statement.
Okay, lawyers, sorry, that took a little longer than expected.
Judge, that just seems like how things are rolling in the month of December.
It's been a crazy, crazy month. It's typical though. For some reason, it seems like the summer months and December are
Yes.
always really busy times for the court because it just is that way, right?
Well, y'all are shutting down. You got Dead Week, not officially shutting down, but y'all start Dead Week right next Wednesday. Is that right?
Next Wednesday, we'll still be here for like prove ups and signing orders and things like that, but there won't be actual contested.
No contested docket.
Mhm. Okay, I believe we left off before we get on the record with, we were still in the direct examination of the respondent by Ms. Phoenix. Is that right?
That's my recollection, Judge.
That's correct, Judge.
Whoops, hold on. Stop
That-
video. I'm not on mute.
We can hear you, Ms. Phoenix.
Okay, I'm sorry. I'm looking at the other thing down here. That's my paralegal.
Okay, we're going to get back on
Okay.
the record. The court's on the record in cause number 20 DCV 271-334 in the matter of the marriage of Lynn Hodges and Gary Hodges. We're going to be resuming this final trial. This is day 3. And we left off from the last day with the direct examination of the respondent by Ms. Phoenix. So we're going to pick up where we left off. Ms. Phoenix, Mr. Hodges, you're still under oath. Ms. Phoenix, you may proceed when you're ready.
Thank you, Judge. Mr. Hodges, if you don't mind, I want to refer you to Petitioner's Exhibit number 1. And this is their proposed property, petitioner's proposed property division.
Yes, ma'am.
And if I may, I'm going to ask you some questions about this exhibit.
Yes, ma'am.
Okay. Petitioner is proposing for financial accounts that all the accounts in her name be awarded to her. Do you agree or disagree with that?
Yes.
You agree with that?
Yeah, her financial
Financial account.
yes.
Okay, and all accounts in the sole name of you be awarded to you.
I agree to that.
Okay, now for retirement accounts, all accounts in the sole name of petitioner, including the HMEPS and City of Houston deferred comp, should be awarded 100% to her. Do you agree or disagree?
I disagree.
And she's asking for 50% of your DFAS plan to be awarded to her. Do you agree or disagree?
I disagree.
Okay, motor vehicles. The 2016 Yukon should be awarded to petitioner. You agree or disagree?
I agree.
2013 Prius and the 2015 F-150 should be awarded to you.
Yes,
Agree or disagree?
I agree, Ms. Phoenix.
Okay. Liabilities, the debt associated with the Yukon awarded to petitioner. Agree or disagree?
I agree.
Debt associated with the Prius and the Ford F-150 awarded to you.
I agree.
All credit card debt in her petitioner's name awarded to her.
I agree, Ms. Phoenix.
All credit card debt in the name of respondent awarded to you.
I agree, Ms. Phoenix.
Business known as AAA Justice awarded to you, subject to a reimbursement. Do you agree with the reimbursement?
I disagree with reimbursement.
But do you agree that the business should be awarded to you?
I agree the business should be awarded to me.
Okay, reimbursement. Their respondents should be found to have committed fraud and reimbursed the community estate for wasting community funds in the amount of $468,625. Agree or disagree?
I disagree. I haven't made that money, Ms. Phoenix.
Okay,
Hold on, I didn't hear that, Mr. Hodges. What was that answer?
I disagree, Judge.
Okay.
Respondent should be ordered to pay $234,000 to petitioner as spousal support for 58 and a half months, $4,000 a month. Do you agree or disagree?
I disagree with Ms. Phoenix.
Okay, confirmation of separate property. This residence at 7003 Desert Bluff confirmed that's her separate, as the petitioner's separate property. Agree or disagree?
I agree.
8,537 from her retirement, confirmed this from petitioner's retirement, confirmed the separate property.
I disagree, Ms. Phoenix.
Sum of 3154 from petitioner's City of Houston, deferred comp, confirmed the separate property.
I disagree, Ms. Phoenix.
Okay, thank you. We're going on to petitioner's exhibit number 2. This is the inventory and appraisement. And we're not going to go through everything, Mr. Hodges. I just have a few questions to ask you.
Yes, ma'am.
That's petitioners 2. With regard to, let's see, page 2 of petitioners 2, this is where the DFAS pension of $1,951 is listed. They are asking that that be considered a part of the community estate. Do you agree or disagree?
I disagree.
Okay, you don't think it's community?
No, ma'am.
Okay.
If that's my military.
Objection, non-responsive after I disagree, Judge.
I'll clean it up, Judge. I'm sorry. Mr. Hodges, why don't you think it should be part of the community?
I had that prior to the marriage.
Okay.
I retired from the United States military in July 31st, 1999. I was
Okay.
married 11/11/11.
Okay, so it was well prior to the marriage.
Yes, Ms. Phoenix.
Okay, with regard to page 3, reconciliation and equalization. This is where they're asking $468,620. I'm sorry, $468,625 be considered waste through withdrawals and other means. Do you agree or disagree with this?
I disagree, Ms. Phoenix.
Okay. And finally, on page 5, there's a Wells Fargo line of credit. Looks like the balance is 24,609. Are you familiar with this?
No, I'm not.
Okay, it says in the name of the account is a husband and wife. Have you used this line of credit?
No, I have not, Ms. Phoenix.
Do you know anything about it?
I do now look at documentation, and I saw earlier documents where I was removed from the Wells Fargo account when I reviewed the documents provided.
Okay, so you've not used this line of credit.
I have not used that line of credit personally.
Okay. So do you think it should be your debt?
No, ma'am.
Okay, thank you. Judge, I would like to, and I didn't get a chance to talk to Mr. Zan before we started, but we've offered, we have rebuttal exhibit 1 and 2, 3 and 4. And I'd like to at least offer those exhibits, Judge, into evidence. I don't know if we need to go off the record and talk about it or what.
We can do that. We're going to go off the record for a second. So on the rebuttal exhibits, it would make sense that we just mark those rather than 1, 2, 3, 4, that we mark them as respondents 66, 67, 68, 69.
Okay.
I think you left off at respondent 65. But Mr. Zan, have you had a chance to look at these rebuttal exhibits yet?
I've had a chance to look at exhibit number 1, Judge, which is, it appears their certificate of written discovery, Your Honor. And
No, it's some check, it's checks, Judge. that we provided during discovery. It's about 1,000 of them, 1,000 pages.
I have no objection, Judge, if it's the exhibits that are previously marked as fourth sup.
Yes, I think
It's
that's
nine
what it is.
914 pages, Ms. Phoenix.
Almost 1,000 pages, yes, sir, that we
Okay.
provided in discovery.
All right, so it's the fourth, so it's basically 900 pages of checks.
No,
Checks
Judge, it's
and
bank
account-
statements and
Bank-
copies of checks, it appears.
Yes,
All right, so I'm sorry, we're gonna get back in the record, but Ms. Phoenix, I'm gonna want that marked as, just for ease of the record, R66.
that's no problem. And Judge, R67 then would be the proof of delivery. It's just let me see. It's I believe the certificate that says that we delivered these documents to Mr. Zan, certificate of written discovery, and the responses, some other responses,
Okay.
discovery.
I'm assuming there's, I'm not, I shouldn't assume. Mr. Zan, do you have any objection to a certificate of written discovery?
None, Judge. It's got an email in it from Miss Hodges' office, or Miss Phoenix's office. But other than that, Judge, I'm looking at it. I think Exhibit 2, though.
R2.
It's not the certificate of written discovery. It's their actual discovery response. Their response, it appears it's their fourth supplemental set of responses to our request for production and inspection.
Yes, it is, Judge. And it also, I believe it was our delivery of documents because it was so voluminous. We put it on, I believe we put it on a flash drive and took it over.
All right, so
It was just saying,
whatever it is there, because I haven't looked at any of these because I can't.
I don't really know why it's relevant to all this, Judge. If I've already stipulated to the fourth sup or to their exhibit number 1, I don't know that exhibit number 2 is necessary, but if they want to offer it, Judge, I have no objection. I don't really see.
Well, and that's the thing, is that either you can object on relevance if you want when we get on the record, or you can stipulate to it. It doesn't matter to me, but I tend to agree. If the bank statements and the checks were provided in the fourth supplemental, then the court's going to be able to look at those. And
okay,
assume that they got them, but that's fine. I'm not saying you can't admit R67. What about R68?
Judge, we did not receive these documents and discovery responses.
Judge, go ahead. I'm sorry.
No, go ahead, Ms. Phoenix. I'm just letting you know, I've never seen these except for when you just provided them.
Well, Judge, these are in response to Ms. Hodges' testimony that Mr. Hodges did not have her covered under auto and homeowners insurance. And we've got these rebuttal exhibits support, will support his testimony with regard to the fact that he's had her covered because the injunction said that he could not change any of his insurance.
Okay, response, Mr. Zan?
Judge Mike, I believe the testimony was that after a period of time, as of June 22nd, Judge, she was not insured. The home was not insured, nor was her vehicle insured, Judge. And I believe the issue is, I don't think that we're aware that there is active insurance as of now, Judge, because my client has a different insurance policy on both her vehicle and the home. And if the court's aware, Judge, we've had a motion to compel and there's been no supplementation of these documents prior to the discovery period expiring. So I'm thinking this is a little bit of an ambush, Judge, if this is the situation.
No, Judge, we're not trying to ambush Miss.
That's okay. We're going to do all this on the record, right? So I don't have
Okay,
to hear the arguments twice. So 68 is not stipulated to.
okay,
And then there's 69. What is?
okay.
That would be the same
Same
issue,
thing.
Judge.
Okay.
It's the insurance that Mr. Hodges had for Mrs. Hodges.
And is that it?
Homeowners.
Is that it on your rebuttal exhibits? Or is there-
Yes, Judge.
And have you
And
emailed
Your
those?
Honor, we have rebuttal exhibits as well, but I guess we'll take those up when I'm able to cross-examine, unless you want to address them now.
Well, if they're going to, Ms. Phoenix, have you had an opportunity to review Mr. Zan's supplemental or rebuttal, not supplemental, rebuttal exhibits?
Yes, Judge, I had a chance and we are objecting to the rebuttal exhibit 1. Well, I guess there's gonna have a different number too,
So it would be 44, petitioner's
40.
44.
44, because it was not provided in discovery. These were copies of checks that are just now being provided.
That's okay. We'll, because I know there, y'all, I just need to know if you stipulate to them. If you don't, then I'm gonna let y'all argue that on the record. So
Okay.
44 is not stipulated to. Are there any other rebuttal exhibits?
There's a 45, Judge.
What about
And
that one?
The same thing, Judge, it wasn't provided in discovery.
Okay. All right. So we'll take up those issues when those exhibits are offered, if they're offered. But when we get back on the record, I'll admit Respondent 66 and 67. It sounds like. All right, the court's back on the record in the Hodges matter. We took a brief recess to look at some rebuttal exhibits that may be offered by both sides. It's my understanding we have a stipulation as to Respondent's exhibit number 66. Is that correct, Mr. Zan, that you're stipulating to the admission of R66?
Yes, Your Honor.
And then R67, Mr. Zan, did you have any objection to R67?
None, Judge.
All right, so R66 and R67 are admitted.
Thank you, Judge. And Judge, we're going to do a screen share. And because the documents are voluminous, I'm not going to go through every one of them, but I'm going to go through some of them if you
Okay.
don't mind. Okay, Kathy.